within the EU. The idea behind this project is to find out in the first place what is the level of awareness regarding these regulations, the regulations that are in force concerning small claims, and second, to elaborate guidelines that would stimulate either legislators or good practices among judges and support for consumers aimed at making these regulations more effective. So I also want to thank very much the HEC Paris administration which supported the event, and Pablo Baquero, who is our postdoc here at HEC, who organized this event. And a very warm welcome as well to Alina Ontano, who is a specialist in the subject. And she will present to us the subject, in particular, the difficulties in the small claims regulation within the EU. The event will unfold in the following way. We will have half an hour, more or less, of Alina's speech and presentation, followed by Pablo's a session conducted by Pablo regarding questions, presenting questions and Q&A on Alina's presentation. So if you have, among the participants, if you have any questions, feel free to write them in the chat, and we will be very happy to take them in the Q&A session. So with no further ado, please, Pablo, do you want to say a couple of words, and then you can give the floor to Alina. Thank you very much.
So just to give a warm welcome to all the participants, and looking forward to the talk by Professor Alina Ontano and to our discussion later about the SCAN guidelines. Thank you very much for joining us.
Thank you for this invitation and for the opportunity to speak about the European small claims that I studied for my PhD, but also later on in different projects over the years. I will start by sharing my screen. I hope you are now seeing my presentation. I will not be able to see you during my my talk. So in case there are questions or anyone wants to interrupt me, please feel free to do. If it's urgent, or we can keep questions for the discussion moment. Well, I will start with a small introduction on the European small claims procedure, because although it has various complexities due to national law and national ways of applying this procedure. So a few characteristics. The procedure is an optional one, so it's not compulsory for parties to rely on it. It is meant for cross-border claims of up to 5,000 euros. This excludes interest, expenses, and disbursements. So practically the principal amount has to be below 5,000 euros. The scope of its application is almost identical to the Brussels 1 bis regulation, that is the backbone of private international law within the EU. It excludes, let's say, matters of employment law or immovable property related matters, except if there are monetary claims, defamation aspects. So these are not part of the European small claims procedure scope, unlike the Brussels 1 bis. The application of this regulation requires that at least one party is domiciled or habitually resident in one member state. And this means that either the claimant or the defendant is domiciled within another member state, and the domicile is to be determined in accordance with the rules of the Brussels regulation, so the Article 62 and 63. Should we consider an intervening party that is situated in a different member state, that does not count for creating the quota. Now, jurisdiction rules rely for this procedure again on the Brussels 1 bis regulation, and this specification is made also in the Annex 1 of the regulation, that is the claim form, in order to guide the potential user in determining the jurisdiction of the national court where the claim has to be submitted. However, there is also a wizard on the e-justice portal that aims to help users determine the jurisdiction where the claim has to be sent. And this is to be found in the European Judicial Atlas in Civil Matters. You see this on lower, which leads you to this select what is the matter that in relation to the application of this procedure. In this case, the other characteristics of this procedure is that representation is not mandatory, unlike some requirements in certain member states where representation is necessary in all procedure. This Europe does not require a representation by a lawyer. The party can choose to be represented, but this is not compulsory. The way it works is regulated in Articles 4 to 19 of the regulation. It is mainly a two-sided procedure. So the defendant is expected to submit a reply to the claim before the court issues a decision. Should the court not receive its reply, it will eventually need to issue a judgment. But in principle, it has to be a two-sided procedure that relies on standard forms. A very important aspect of this procedure is the fact that parties are not required to make any legal assessment, only describe specific elements of their claim, the documents, the interest, facts, and attach documents. The oral hearing is not necessarily requested by the parties or the court if retained necessary. I will come back to this. And there is no exequatur procedure. So once the decision becomes final, a certificate is issued by the court of origin, and the decision will circulate freely within the EU member states, with the exception of Denmark. So practically, there should not be any additional administrative requirements for the recognition of that decision. Also, this procedure does not contain any grounds of refusal except the fact of irreconcilability of judgments. So unlike the Brussels 1 bis, here you don't have the grounds of refusal that can be invoked by the parties, except the irreconcilability. Now, looking practically on how the procedure unfolds, the claimant will fill in the then copy of this claim form and the documents submitted, additional documents submitted by the claimant, together with the Form C, which is the answer form, to the defendant. And as I was mentioning, oral hearing is not compulsory, but might be requested or considered necessary by the court. In practice, this is not often the case now. It was more at the beginning that courts would order automatically a hearing. This was mostly due to the fact that the procedure was not so well known, and hearings are often compulsory in national applied a bit in the framework of the national familiar procedures.
Alina,
judgments should be issued within 30. Yes.
Okay, yeah, sorry to interrupt you. Your
Yes.
connection seems to be not very stable. We can understand everything you say, but so I suggest you, if you can like
Yes.
turn off the camera, maybe it can like make your connection lighter, because I can see when you use the website it's lower. So is there, I know this puts a lot of pressure on the speaker. I'm sorry about that. So it should go well now. Okay, thank you very much.
No
Sorry
problem.
about
Thank
that.
you a lot for letting me know. I hope you can hear me better now.
Yes, yes, we can.
Should I repeat any part?
No, I think it was okay. We can follow you very, very clearly. It just slowed down your speech, but then it came back, so it's okay. Let's move on. Don't worry about that. Okay, thank you very much.
Okay, thank you. Yes, thank you. Now, an important aspect and also a problematic one within the procedure is the service of documents at the moment of notifying the defendant, but also on serving the judgment, because the court should proceed to service, but this is not fully compatible with national procedure. Rules, because in certain that has this duty. Another aspect that is problematic in the service is related to the fact that postal service is different. So not all member states have an acknowledgement of receipt, a paper acknowledgement of receipt, or it is not clear what information should be filled in by the receiver. Whether that is the defendant or someone of his household. So that creates problems in practice and leads to delays of the procedure. Well, shortly, the enforcement, I already mentioned that a certificate is issued by the court that issued the judgment, and then the creditor, the claimant can proceed to enforce should the defendant not willingly comply with the judgment. That is the appeals. Appeals are not uniform under this procedure. So this is an aspect that is left to the specificity of member states. Following the review, the amendment of the regulation in 2015, when the amount of the small claims has been raised to 5,000, this appeal possibility has been enlarged in certain member states where previously appeals were not possible. This is, for example, the case in the Netherlands. Although appeal remains quite limited in grounds for claims below 1,730 euros. So for limitation, if I remember correctly, for claims under 4,000 euros. And there are systems where you can have 2 degrees of appeals, in others 1. So again, national specificity play a role in the application of this procedure. And should there be situations when the defendant was not aware of the claim that was issued against him, it has a period of 30 days to request a review from the moment it was aware of the documents. And these situations are exceptional grounds. It's not a procedure that is aimed to supplement an appeal. So only for exceptional circumstances where the defendant was not served with the documents or he was unaware of his offense, he only knew about the claim within a short time before a hearing, or there was force majeure or exceptional circumstances. Well, in France, luckily, implementation legislation has been adopted quite soon after the adoption of the regulations. However, over time, rules did change a bit in terms of court competences or theoretical possibilities of filing claims online. I understand that in practice, this is not easy or not yet the case, especially for claimants that are not French or don't have a residence in France. Guidelines for 2000 are no longer applicable, but they were meant more for professions, for courts dealing with these claims and not for the actual users. As in France, situation is quite variable around member states, and I give you some examples here. And although, let's say, not specific implementation means have been adopted, national rules still can be relevant for the application of this regulation when it comes to the court being competent, territorial or court fees, possibilities to make use of electronic means for hearing or servicing. So then in this situation, court practitioners and users have to navigate are adopted. And in this, the e-justice portal that I have previously showed you some parts can be of help. However, there also information on certain issues can be quite generic and send you to national legislation. Now, turning to practice, several researches in which I participated have revealed that three elements are particularly problematic in practice. This is jurisdiction, language aspects, and service of documents. Jurisdiction, when we consider this requirement, use of a municipality in France as Toulouse, you will end up with at least two competent courts. Situation is similar also for other cities. So you'd have at least two courts competent, but no additional criteria as a lay party to determine which of the two would be the right one. This is still a minus that has not been dealt yet with. Luckily, sometimes commerce rely on the European consumer centers or consumer authorities or NGOs to guide their steps in case they are not able to presentation. Similarly, for companies or small companies, you have Enterprise Europe that gives advice in dealing or finding your way around as a party that is not a repeated user with this procedure. Now, a further development related to the application of this procedure concerns the claim forms that lay parties consider quite difficult to deal with due to perceived complexity and technical language, although the small claims forms are considered easier than the ones of the European Order for Payment. In practice, will be sufficient for the court and for the parties in, let's say, providing additional explanation for the court or information. So then, in practice, you would have practitioners, parties, courts relying on national formats. So further flexibility is needed. A plus that was not previously possible is the possibility of partially filling in forms, saving them, and later on continue. This was a complaint from practitioners that need to fill in the forms in one go. Apparently, this has been dealt with by the Commission. Now, turning to language related aspects, there are several consideration to be made, and maybe this is advantages that might be necessary in the application of the European Small Claims Procedure. That is the language of the proceedings of the court. It might be different from the language in which service of the claim form and of the judgment needs to be carried out, and of the certificate of enforcement. So there are three moments when language can play a role. And when it comes to specific characters, because some member states have alphabets that can also create some problems at the moment of recognition. The certificate Form D in certain member states, and if we take the example of France, can be carried out or used in 5 official languages: French, Italian, Spanish, German, and well, I thought also English beforehand. I'm not sure now with be living, whether that there will be some changes. However, when it comes to the actual use of certificate in all these languages, I have some doubts that actual bailiffs are able to use all these languages at the same time. I'm saying this also from my own perspective. Although I speak several languages, I would not be able to deal with the certificate in all 5. Unfortunately, German is not very good. And this is something parties encounter in practice, even in jurisdictions that are very friendly with such language requirements. One point of attention is that the acceptance of several languages, official acceptance of several languages, is related to Form D, to the certificate, and not to the claim form or other forms. Although in practice, there are countries where judges are a bit flexible in dealing with forms that are in a language that they can understand or read. For example, in the Netherlands, they would easily deal with forms in English or German. Now, moving on, maybe I should speed up and faster given time constraints. Well, with related to already mentioned most of these aspects previously, so I'll go to the oral hearing. Here, developments have been made to facilitate the use of this procedural step via distance communication technology. And I think during the current times, this can be a very useful possibility. Although, as I mentioned, there is no indication that hearings are ordinarily used by parties. If you consider it necessary, I can further develop on this during the discussion. Steps are there to make the procedures more technology friendly in the future. Although at the moment some technical aspects, some technicalities are not allowing the use of the procedure in an electronic format. Enforcement is also a step, a final step of difficulties for the European small claims procedure because there is no procedures. Information is limited on the European Justice portal and mostly general, or it refers to national websites where information is only available in the official language. Also, costs are not very clear from the information that is available. Well, looking at case law, there is no huge richness in case law that I could go about in France. However, it seems that the procedure is mostly used in relation to online agreements or aviation cases. And this is what appears from case law in other member states. So you still have a huge hub for such use of the European small claims procedure. And it seems that not only consumers are the ones that act as claimants, but in certain countries also businesses make a big use of this procedure, although the initial aim was to design a procedure that is meant for consumers. More on national case law related to the European small claims procedure, but also other uniform European procedures, you can find on this website that provides insight into the results of the informed choices in cross-border enforcement projects. So there is a database for the ones interested in finding out more on how national jurisdictions deal with this procedure. The information is available in English with links to the cases in their national official language. Now, to conclude, what should we consider for the future of small claims and cross-border small claims? Well, I think there are three considerations or three areas, three approaches to look to in improving the use and the application of this regulation. First, the measures that are related specifically to the regulation itself. And here more efforts are needed to provide knowledge and information to parties, but also practitioners, and deal with aspects that can be summed up as practicalities, specific information to facilitate the application of this regulation, because often specific information is only available in the national language and not structured in a way that is easy for lay users, for not. I think procedure in a toolbox format. So not only the European Small Claims Procedure, but look at what other procedures, court procedures are available to deal with the same issue. And given the circumstances of a specific case, consider what is the best option as obtaining a title, but also in enforcement stage. I think we should consider this integrated format that then we tend to do now. Look at each uniform procedure, national procedure on its own, but more how can they interact and help each other in choosing the right format for the specific case. And last but not least, look at small claims not only from a court format, court proceedings, but also in an out of court or instrument. At the moment, the articulation between out of court solution being the traditional format or online ones and the European Small Claims Procedure is not very tight. The ODR platform does refer to the European small claims or the European order for payment should an alternative solution not be reached by the parties, but we don't have the uniform procedure. There is no express relation. There is a possibility to for the court to facilitate settlement, but this is not often the case in the small claims procedure. And written less possible or considered by the parties. And this could be this connection, this relation between the two sides, the out of court and the court instruments in dealing with small claims might be integrated via the ODR platform, the e-justice portal, or even the e-codex project. A project that has been fully online of the European Small Claims Procedure in the previous years, and might be the instrument that will be more extensively used within the EU in the coming period, or at least after 2023, given its proposal the European Commission submitted in December last year for creating a regulation that creates a e-platform. I would leave my presentation at this. I hope I have not exceeded my time too much, and I remain open to questions and to the discussion should I need to intervene.
Thank you, Alina. The connection wasn't great, but I think we were able to follow. Also, thanks to the slides. Thank you very much for this presentation. Now I leave the floor to Pablo.
Right. So now we're going to have the opportunity to discuss a little bit the guidelines, the recommendations that we have produced in the context of the SCAN project, and particularly focus during this discussion on those guidelines that we consider to be relevant and particularly important in the French context. So I'm going to raise some of them and comment them and ask for Professor Alina and if other participants want to jump in to comment on them. So one of the guidelines that I would like to mention that we have produced in the context of the SCAN project is the proposal of the creation of a centralized translation center or an online platform that provides translation services across the European Union for potential users of the ESCP proceeding. And we think this is particularly relevant in the French context because there is no public institution, there is no other entity that could provide assistance to potential ESCP users to translate the required documents. And as we have seen from Alina's presentation, there's a number of documents that we might need to translate when we are using the SCP proceeding. One example of that is the Form A, which is the statement of claim whenever one party wants to start the claim in another. That particular form has to be translated into the language of the court that will receive the statement of claim. So my question to Alina and for all the other participants that would like to jump in is, to what extent do you think that are there other initiatives already in place to promote centralization of translation services in other EU member states? And to what extent do you think that this proposal could help us to improve the effectiveness of the SCP proceeding?
Well, to quickly react, I don't know of a centralized translation center initiative, but I would say there are certain possibilities considering the ODR platform that, let's say, for the first stage, the claim form, it does facilitate the claimant in translating part of its claim of what is the problematic aspect. So if you think of that approach of the platform, maybe standard not be so unusual to consider the small claims that is a self-dealing with procedure, not needing representation. Another development that I'm aware of, but is national, is in the Netherlands, where the court in The Hague that deals with the European Order for Payment, so it's a centralized court. They have their own translation services. But this is, let's say, some specific example.
Thank you. Do we have anybody else who would like to jump in at this point? Or so the second guideline that I'd like to bring to attention of the workshop is the need to promote the digitization of the ESCP proceeding. So there's a number of recommendations that have been developed by the SCAN project that judicial authorities and courts, they should take the initiative to promote, to find the infrastructure needed for courts to undertake video conferences, to promote the filing, the service. And again, we believe that this is particularly important in France because we have already legal provisions in force that allow, for instance, for video conference or a service to be conducted. But in practice, we see that this is not actually happening. So then the question would be, what do you believe is the main or the initial steps that we should be taking in order to promote digitization? Is it a problem of resources, of lack of infrastructure? do we need training courses for the involved actors? What would be the different steps that we have to undertake to promote this digitization of the SCP proceeding? And once more, I think this is a particularly important topic, especially now in the midst of the pandemic, when all of us depend so much on digital resources to be able to keep in touch and to conduct our activities.
I can reflect a bit on this, unless someone else wants to share his or her views and knowledge. Well, I said there are several aspects to deal with. One is the national infrastructure, and I think the electronic infrastructure for courts is not uniformly developed, and in certain cases quite poorly. Without wanting to give names, there is an Eastern country where even courts in a big cities have poor internet connection, so the judge would need to fill in the forms at home, because otherwise in the court would not be able to finalize the form from beginning to the end due to poor internet connection. Finances are also one point, or can be a point of reference, because developing a national infrastructure or reinforcing a national infrastructure requires financial resources, but also I think that the programs would need some transformation in order to become appropriate for receiving claims from abroad, if you want to receive claims electronically. And I think there you also need some training of practitioners in dealing with. Of course, if you have a smaller number of courts, not all courts competent, that might be easier to do. But if all courts are competent, that might require a bigger effort. One possibility, let's say, to facilitate this development of national infrastructure might be the proposal that I was mentioning to you on the e-codex, because their national authorities can also, or there is the possibility for national authorities to require financing or to receive financial support from the EU to develop the necessary infrastructure.
Right, and another question, which is, sorry, please go ahead.
No. I was done.
I just wanted to make another question, which is connected to that, which is the importance of alternative dispute resolution and online dispute resolution. Again, in the SCAN project, we have this recommendation that judicial authorities should find ways to promote ADR and ODR within small claims. And sometimes you see in the literature some dichotomy between ADR and ODR and small claims. Sometimes authors say, oh, because you have already ADR and ODR happening, like those traditional proceedings of small claims, they don't remain as relevant. But one of the ideas of the project is that perhaps there's a way to combine those capabilities. I just wanted to hear your reaction to this idea to compatibilize ADR and ODR with small claims.
Well, I don't see these instruments excluding each other. I think it depends also very much on the system. You have countries that are more friendly towards alternative dispute resolution, or where you have very good ODR bodies for specific types of matters, and they function very well. And if that is the case, then you don't really need to rely on the a court procedure, such as the European Small Claims Procedure. But you have also countries where ODR, ADR are not so developed or are not so often used or chosen by the parties or the claimants, because simply there is no tradition in that direction, and people might be a bit reluctant in choosing some instruments that they're not familiar with, or they think it's something strange, I don't trust it. If that is the case, there should be an alternative, and I think all can contribute to facilitating access to justice. And if our ODR bodies comply with the proper access to justice and independent solution, I think, yeah, they all contribute to access to justice, and they do not, or what should done is present them as alternatives.
Thank you. Do we have any other participant that would like to jump in this topic of digitization or make any observations before we move on to the next guideline?
Could I?
Please.
Yes. Good evening, everyone. I'm Martina Tonetti, a lawyer from Italy. And I think that ADR is the way to proceed, especially for small claims. I mean, for small claims, the main issue is the cost of the procedure. So choosing an alternative dispute resolution is the best way to really resolve the problem parties gave us. I think that's the first thing to improve.
Would somebody else would like to respond or react?
Can I ask one question? It is a question for Ms. Martina Tonetti. When you refer to cost, do you refer to court fees or other type of costs that you would have in court procedure compared to ADR mechanisms?
I mainly refer to court fees. Yes.
Okay. Mm-hmm.
And well, in Italy, ADR is much more cheaper than court fees and court cost and lawyer cost. So especially with small claims, I think that ADR is much more better to really resolve the questions.
I agree with you that sometimes it can be the right instrument. However, when it comes to court fees, is very. Can you hear me now?
No, yes.
Can you hear me now?
Yeah, yes.
Sorry for this. I'm saying that when it comes to court fees, this is why I'm also saying that one should not exclude the other. There are countries where, for example, consumers do not need to pay a court fee. So there you, let's say both of them competitive. There are systems. This is why I'm arguing for having more tools and deciding which one.
That's it.
The situation.
Right, thank you. So I think we still have time for one last question that I would like to particularly ask you, which regards our guideline, this guideline that or recommendation that we have proposed in the SCAN project, that there should be an express provision allowing for class actions in the SCP proceeding. And again, this is an important clarification to be undertaken in the context of French law, because in France, for you to start a class action, it has to be started by one of the national consumer associations that are nominated in the legislation, which I think it's up to a number of 15 consumer associations that can start a class action in France. And it's even unclear under the SCP proceeding if an association can bring a claim. So I just would like to hear your reaction about how productive would be for the SCP proceeding to have this express provision on class actions.
My first thought when considering the class action question is how would they manage with the standard forms? Because they can be quite, let's say, challenging in more complex cases, and not flexible enough to deal with what is necessary in terms of information or several rounds of information. How would you do that for a class action that has quite a number of particularities? Okay, there are similarities, but also differences. And how do you deal with all that based on the forms that now, for either the forms are more flexible or, yeah, I'm not sure. Let's say it can be truly a class action integrated into the small claims, although you can see, for example, for aviation claims, especially now that sometimes specific consumer or businesses that deal with this type of claims bundle more claims or similar claims from, let's say, passengers from the same flight together in filing European small claims rather than filing several cases. This is the situation for case law in the Netherlands. So definitely it happens, but it does not bundle hundreds of cases or thousands of cases, but I think up to 5 claimants. I'm not sure that is a true class action.
Right. So I think we would maybe still have like time for one reaction before wrapping up, if anybody still wants to make a comment or question.
Yeah, there is a message I received from one of our participants, Claudio Pezzi, who is also a friend. So, so I read this question. It's more, I guess, it's more a comment, but let's see where this goes. So the small claim procedure instrument could really be of great help in providing judicial response to claims of limited value. I must say my experience in Italy, sorry, I've lost a little bit the text. Yeah, I must say that my experience in Italy is so far a little disappointing. So this is a practitioner speaking. I must, there are, sorry, I continue receiving comments. Okay. I introduced 2 proceedings before Easter 2020 in the business courts of Milan and Naples, and up to now I have obtained for one proceedings in December the fixing of a deadline for notification in January, and therefore hopefully I could have an outcome by February. For the second proceeding, I obtained a positive measure in September, but it was the surprising granting of an European injunction, therefore a measure that I had not requested. Therefore, in this proceeding, I asked for the revocation of this erroneous measure to the judge, who thus set a deadline for the notification of the request to the respondent with a hearing in June 2021. These cases of mine demonstrate the difficulty with which in Italy we have to access to a procedure that was born with the spirit of quickness and conciseness. I have a question regarding the assignment of rights and jurisdiction. Except for an elusive phenomena, it seems to me that the assignment of the right is compatible with access to the procedure and allows a sort of forum shopping. There are agencies/companies in Europe operating in the field of air travel compensation or in the copyright sector, which gather large numbers of clients from different countries and exercise judicial protection for them. This is very, my note, this is very interesting. The assignment of the economic right could therefore lead to the situation of a claim relationship discussed with the small claims procedure, both contractual and non-contractual, even though it originally arose between persons from the same country. Also, it may happen that the creditor of a debtor, from the same country assigns his claim with recourse to a subject from a different member country, allowing him to take legal action under the small claim procedure, enjoying the advantages of speed and simplicity compared to the ordinary proceedings. Is it possible, therefore, to think of a competitive choice of judicial instrument, preferring the small claims procedure to the more time-consuming and expensive ordinary ways, through the use of instruments of assignment of the litigious rights? Thank you, Claudio. Please stop there because I think the time is over. But the question is very, very clear, right? So we have one part of the question concerns the frustration of having either too long, too much length in the proceedings, or judges not to understand really what the procedure is about, which again make us come back to the question of awareness among judges. And the second is this problem of assignment of rights, like business companies that collect claims and then they redistribute claims to judges of different countries using the small claim procedure. Thank you, Claudio.
Should I react based on my knowledge?
Please.
I will turn my camera off, and sorry if the cat meows, but I have a kitten that is a bit chaotic this evening, no besides problem. My internet. Well, in the Netherlands, this is a big business, aviation claims, and some are very, very active in this. What they do is they try to apparently deal with the claims in the Netherlands because they expect or they know that the courts are more friendly towards the consumer in getting a favorable decision. However, if I look at the lawyers that are sometimes representing the companies, the big companies, sometimes they choose also the claims for which they do not reimburse consumers because they want to get decisions that can help them in their gray areas in the application of the regulation 261 2004. So let's say that the players, one play on the business part because they get a small percentage. The others because they want clarification in how to deal with certain type of issues in gray. areas. In doing this, also the courts that have competence are 2 or 3. This means that the courts in these aviation matters, or where they receive claims or a large number of claims, they're quite good in dealing with the procedure after a while. So they're very expedite in dealing with them. The delays in terms of procedure, from what I know, and also speaking to judges, is because of their workload. So you can have a procedure that is meant to be fast, but it might end up not being as fast as it is meant to be. Sometimes internally, let's say they try to assign the cases to the judges that would be arrangement that each court can take. And in certain systems it's not possible, because the way cases are assigned is aleatory by computer program. Of course, you can argue that you can learn how to deal a bit with the system, but you cannot completely change the way the cases are assigned. Another situation from the Netherlands in related to this assignment of claims, and where, let's say, the cross-border situation is created a bit artificially. The courts in these situations consider that the case is not cross-border. So they, at least that the cases that have been published, and I got to, or from discussing with judges, they simply consider that the cross-border situation has been created by going further than what the regulation requires, and they do not handle them as small European small claims. But I don't know what happens in each
That's also interesting.
member state.
Sorry, Alina. It's also interesting to see how this I don't know much about this, but it's interesting to see how the companies are taking advantage of probably of the flows of the same regulation and try to transform these flows in a business opportunity, in the sense that that the market can help or can be impact negatively the possible implementation of these small claim procedures, right? Okay.
Indeed, I do think it can shape the way the procedure is used or not. And training the judges is important. And I do some trainings for judges for the European Judicial Training Network on this procedure. But I think it's also very difficult for a judge to be very good with such instruments when they hardly apply it, or they apply it once a year or once every, I don't know how long. Then simply you forget certain technicalities, or you need more time. And maybe this is why a bit of concentration of these claims can help courts deal with the procedure.
Okay. So Pablo, do you want to close the event? On my side, thanks very much to all of you and for these very stimulating questions. Thanks for this. If you want to see this conference again, maybe you didn't catch exactly some points and want to raise reflections upon them, we will be posting the event online in the SCAN website. So thanks so very much. Take care and stay safe. Pablo?
Yeah, so I just want to echo Mateo's words to thank all the participants of the workshop, and particularly to Professor Alina Ontano for her very interesting talk and for her her great engagement in our workshop. And just to say that we're going to be posting soon this presentation in the SCAN website. So thank you very much, and we'll keep in touch digitally. Bye-bye.
Bye.